Welcome to episode 10 in the first season of Justice Center Weekly, a half-hour video cast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me today is Quebec-based lawyer Samuel Bachand, the director for JCCF French-Canadian Operations. He's going to fill us in on a new case supported by the Justice Center. This involves a British Columbia Christian organization, Harvest Ministries International, and the Quebec provincial government. Welcome to the show, Sam, and 3, 2, 1, go. What is this all about?
Well, in a nutshell, Minister of Tourism, Caroline Proulx, picked up the phone, called the CEO of the Quebec City Convention Center, which is a Crown Corporation, and Madame Proulx told the CEO that he ought to break a contract that the convention center had signed with our client for rental of a large room for many days. And the contract had been signed in January of 2023. So the CEO complied with the request of Minister Proulx, and on June 2nd sent a very terse termination notice to my client, saying that, well, the event would not take place at the Quebec City Convention Center, and that was it. So the event had been scheduled for June 23rd, to July 2nd, and this is the high season in Quebec. Obviously, the rooms are rented almost everywhere. So my client is in trouble right now, and fortunately, to my knowledge, has not found yet a new venue for the event. This is all very reminiscent. You know, this story about the minister calling the CEO of the Centre des Congrès. This is all very reminiscent of a well-known Supreme Court of Canada case from the 1950s, where Premier Maurice Duplessis, who was all-powerful back then over Quebec politics, was angry about a rich restaurant owner in Montreal, Mr. Corelli, who was paying for bail for Jehovah's Witnesses. So Maurice Duplessis said, I don't like this guy, calls the president of the liquor board of the province of Quebec and tells the president of the liquor board, you ought to pull the license from Mr. Roncarelli, his liquor license for his restaurant, which the president of the board did. And then Roncarelli obviously sued. The case went all the way up to the Supreme Court of Canada, and that led to a landmark decision or judgment on the rule of law and, let's say, certain principles as to abuse of power by public authorities. So I expect that when we file a claim in damages and charter declarations, in this case, the ultimate result will be very similar to that of Roncarelli Duplessis. And I mean favorable to us and unfavorable to Minister Proulx and Mr. Bouchard, the CEO from Pierre-Michel Bouchard, CEO of the Quebec City Convention Center.
Well, I guess we should clear up a couple of things. First of all, the Roncarelli decision was because, well, the reason that the premier called up was that the fact that Roncarelli was a Jehovah's Witness, so it was religious. There was religious reasons for him trying to ban him from having a liquor license. In this case, what are they alleging that the Harvest Ministries International has done?
Well, at first, Minister Proulx told the press that she had demanded that the contract be broken because Harvest Ministries was to hold an anti-abortion event, which is an absolute falsehood. Our client is a Christian organization, certainly with, pro-life views, but nothing in the planned event at the convention center in June had anything to do with abortion issues. So then, in the following days, the message from the Parliament Hill or Assemblée Nationale Hill in Quebec became, well, they hold values that are incompatible with the fundamental principles of Quebec, which is a very vague thing. To my knowledge, the fundamental values of Quebec are stated very clearly in the Quebec Charter of Rights and Freedoms. And those values and principles and rules of law are very, very, very similar to those of the Canadian Charter. So I don't really understand the whole arbitrary concept of fundamental values, which sound a lot more to me like the personal opinion of a given minister in Quebec at a given time, which is, basically the definition of arbitrariness.
Okay, and so you say that's what she first said. Was there any backtracking after that, or did she change the
No,
story, or did she
no, she
stick to
didn't.
that?
As I said, first they said that it was because the event was anti-abortion per se. And then they said it's because
Okay.
Harvest holds anti-abortion views. But
Oh,
they didn't budge. We
okay.
put them on notice, formal notice, saying, look, this is illegal. There's no
Right.
contract basis for termination. The charters are very clear on this type of issue. My client benefits from freedom of
Mm-hmm.
religion, expression, peaceful assembly, and obviously the right not to be discriminated by either private actors or the state in the provision or offering of commercial rental facilities, for instance. So, look, the minister was obviously unaware of the content of sections 3, 10, and 15 of her own Charter of Rights and Freedoms. This is the sort of stuff that we ought to know in high school.
Yes. So I get it now. It's
This is basic civics principles.
right.
So look, that's the situation.
Okay. So you haven't filed anything yet on this, from what I infer from what you're saying.
No, we expect to be filing a statement of claim by the end of the month of June
So the event
this year.
has to pass. Is that the reason, or is there another reason? Are you giving them a chance to backtrack?
Well, for now, the event we have given them a chance to backtrack in the mise en demeure, the formal notice. We gave them a few days, but they did not. And unfortunately, as soon as Minister Proulx went to the media on June 2nd saying, well, haha, I told my CEO, because it's like her pet or I don't know what, but she's possessive. She says, it's my CEO. I told him to break the contract. Well, as soon as she did that, um, a lot of harm was done. And, it's basically dog whistling to all the other owners, private owners of facilities, not to offer a room if they have any left, any available, because of the controversy. And it seems to work very well up to now. So, unless things radically change, I don't think the event will take place at all.
Okay. Maybe we can just go back to what the minister said regarding the fundamental values of Quebec, or Quebec's fundamental values. Have they pulled this on anybody else, trying to define the Quebec fundamental values in canceling contracts or any other cases like this?
But I've never seen that before. So that's
Okay.
why I said that the Corelli case is so reminiscent because it seems very obvious to me that government are supposed to know they can't do that sort of arbitrary and targeted decisions on discriminatory bases. And Roncarelli was rendered in the Roncarelli judgment was rendered in 1959 before the charters were ever enacted. And still, the government lost big time. But now we have the charters in addition to the rest. So not only civil liability and broad principles of rule of law and the role of government in a liberal democracy. And now everything is stated very clearly in the charters. So look, to my knowledge, this is a first
And it sounds
since
like
the Roncarelli case, but I may be mistaken. I'll certainly run a case law search before we file.
mhm.
But I'm sure the precedents, if any, are in our favor.
Yes, I know that the Quebec government has run up against some objections for religious discrimination in the past, and this had to do a lot with hijabs and
Mm.
religious symbols and things like that. Is any of that relevant here?
Well, yes, the again, it will certainly help interpreting the notion of religious freedom and discrimination. But if you are alluding right now to Bill 21 on the
Mhm.
laicity of the state or secularization of the state, well, at least, and I'm not saying it's a good excuse, but at least the Quebec government back then, when it enacted a law, a statute, which is not the case here with Minister Prou, it's just a phone call or
Right.
email, whatever. Well, back then with Bill 21, they enacted a statute and they inserted a notwithstanding clause in it so as to be shielded from judicial review under the charter, Quebec Charter and the Canadian Charter. But here you don't even have a regulatory statutory basis for what was done to my client. It's just like, the dictator in a banana republic taking the phone and saying, well, look, break the contract, sir. My CEO, my CEO. That's funny.
It is
So there
certainly
you
an
go.
odd. Is that convention center under her jurisdiction? Is that why she's making this claim of possessiveness?
Well, she's the minister overseeing the uh, Quebec owned or provincially owned convention centers, certainly as
Okay.
the Minister of Tourism, but that doesn't mean that she can do anything at all. She's just the minister overseeing their work and reporting on. They report to her, and then she reports to Parliament or the Assemblée Nationale, the legislature. Sorry, but again, nothing was done in due process in this case.
The media has paid some attention to this. I understand that is the Quebec media. Is that helping or is that
Mhm.
hindering at the moment?
Well, I have to say that the media, even legacy media, are very interested in the case. It's been going on for what, 10 days now, and they are still very interested in the case. I got calls from English language and French language media this morning, even. And the overwhelming majority of pundits and journalists seem to be in favor of our client, not because they are pro-choice, pro-life, I mean, but simply because they believe, as I hope a majority of Quebecers and Canadians also believe, in freedom of expression, freedom of peaceful assembly, freedom of religion, and the right not to be discriminated on such bases.
In your interactions with these media types, are you talking about the Ron Corelli decision at all?
Of course, I even cited Roncarelli in the formal notice, which was made available to the public early on.
Okay, so they're enjoying
But
this aspect
I'm
of.
not
Oh,
satisfied of
go ahead.
what I mean is that a few of the journalists or reporters mentioned the Roncarelli citation, but I'm not satisfied of the level of inquiry of the media up to now regarding the actual provisions in the charter that might apply, uh, and that I believe do apply, and very clearly. So I'd say that in the next few weeks we'll be preparing the statement of claim, and at least when that pleading is out and publicly available, well, the whole reasoning around fundamental freedoms and the rights to non-discrimination will be fully explained, and we might see some items in the media about that.
Oh, good. Yeah, I don't know whether we've seen anything in the English media yet, that is on this side of the country regarding this case. But I know the Ron Corelli decision, John and I have discussed that several times on our podcast. So, it's something that at least is getting a little bit of play. Now that we're on the other side of the charter, I guess, since that was 59 and now we're on the other side of the charter, is this really a test case then, or is this not really, because it's already been decided in the Ron
No,
Corelli decision?
it's the opposite of it.
Oh, okay.
To me, it's the opposite of a test case.
Mm-hmm.
It's much closer to an open and shut case against the government in Quebec. But again,
Okay.
I'm not going to say it's 100% guarantee. As a lawyer, that's not what we do. But it's as close to an open and shut case as anything I've ever seen in constitutional law. So I look forward to getting their argument. But this might be a situation where the Attorney General will plead against its own boss. It happens sometimes. It's rare, it's uncommon, but it happens. It happened recently in the Nword Saga with the CRTC. I don't know if you want to get into that, but
Yeah, go ahead. Give
that's
us
the sort
that
of
example.
situation where, okay, well, basically, Radio-Canada, the French branch of CBC, was blamed by the CRTC for allowing hosts on a radio or TV show, variety show, to quote the title of a very well-known um, essay in political science written by Alain Vallière, which is called Nègre Blanc d'Amérique. It's taught in high school, okay? So it's nothing very controversial. But the CRTC found that the hosts of the show had said the name, the title of the book too many times. So it was something like 4 times, and this was, unacceptable and rude for people of color, etc. So that was the decision of the CRTC. And then, thankfully, Radio-Canada appealed to the Federal Court of Appeal. And in the Federal Court of Appeal, the Attorney General of Canada was so embarrassed with the CRTC's decision that they decided to plead in favor of Radio-Canada. So the CRTC was all alone there, and the court, to ensure due process and impartiality, etc., well, not impartiality, audi alteram partem, the court asked a law professor from Université d'Ottawa to come and argue the case for the CRTC as an amicus curiae, as we say. But still, the decision was, very clear, and the CRTC was blamed in its turn by the Federal Court of Appeal, because indeed there is such a thing in our land as freedom of expression, and this includes the right of TV show hosts and radio show hosts to mention the name of a well-known literary or political science work.
Okay, so it's a little early days to anticipate anything like that happening in here, but you could certainly see it happening because, in your view, this is such an open and shut case. Is that what you're implying here?
Well, I hope it will happen because the Attorney General And this was an issue with the former Attorney General for Canada, who had a spat with Trudeau back then about the SNC-Lavalin criminal case. But attorney generals in our land are supposed to be independent from the political operatives. And if they are asked to defend something completely ridiculous by they're not their bosses, they're clients, actually. So the government would be its client. Well, the Attorney General ought not to do that. It ought to have a modicum of uh, professionalism and independence and not go and defend ludicrous causes or position, rather. So I hope it will happen here.
Okay. And if you do sue, I noticed in our press release here that they were looking for not only the damages due to the losses, but would be seeking other damages as well. Is that the potential here?
Considering the egregiousness of the conduct of the minister and the CEO and the charter breaches, there will be punitives claimed under the Quebec Charter and also charter damages under Section 24.1 of the Canadian Charter. There might be moral damages, compensatory in nature, asked also. So this is all in addition to the economic losses, obviously, the economic harm that was caused, which should be compensated in full as of law.
Okay, so to clarify then, in this action, if you file, you will be filing not for necessarily a judicial review, will you? Or are you going straight to a lawsuit, civil action? Is it, have you determined yet how you're going to approach
Well,
this?
look, one one could argue that the charter declarations that we'll be asking, maybe I forgot to mention, but we'll be asking declarations of unconstitutionality. So
Okay,
to a certain extent, those declaratory conclusions are in the nature of a judicial review.
okay.
But and without prejudice, we might change our mind, but I think that the procedural vehicle for the whole lawsuit will be a statement of claim and damages. And then we'll insert declaratory conclusions because the main remedies we'll be seeking are damages. So that is not typical to a judicial review
Yes,
application.
the reason I was asking was more for timing because we know we get timely action with judicial reviews and civil cases in Canada can stretch on for years and years. So that's why I was trying to draw a distinction there.
Now, as I said, as I mentioned earlier, unless circumstances change radically, uh, the minister and the CEO killed the event, and they did very early on. So going to judicial review right now, or yesterday, or the day before, would probably not have changed the situation. Otherwise, we would have gone to court directly.
Right.
But I don't want to get into the details. They'll all be in the statement of claim. But if it's not possible practically, there's no point going in and getting an injunction. If it's too late, if it's too late, and the government will have to live with that and to compensate.
Okay. I just want to ask you about the media coverage. You mentioned that the media is contacting you to discuss this. When you're seeing their articles, are you getting any feedback from the government in the media, through the media? Do we know what they're going to argue at this point?
Well, the only feedback we ever got was through the media, because Minister Proulx and CEO Bouchard did not have the basic courtesy of replying to the formal notice directly to us. So we had no news at all, no response at all from CEO Bouchard, and reporters on Parliament Hill in Quebec City asked a follow up to the minister, and the minister said, "We're not budging. Our decision
So,
has been made."
okay. So that's the only you did get that through the media, but not directly to you. So okay, I guess we
But
understand both.
this is the first time in my career I look,
Go ahead.
I'm what 12 years or 11 years in this career at the Quebec bar. Um, I've practiced public and constitutional law for a while, and never in a case against the government or a government entity have I not gotten a written response from the opponent like this. So this is very discourteous from them. And I would certainly venture to say that it's somewhat of a coward conduct.
Would this type of behavior prejudice their case in any way? You know, the fact that you had sent them a formal letter and they didn't reply, does that prejudice their case? Does that reflect badly on
Well,
them in the
it
court?
I think it does.
Okay.
We'll certainly argue that, but that's not the basis for our claim, obviously. It's just that
Right.
they have persisted in their egregiousness, and I expect that they'll continue to do so until the bitter end, when they will probably be condemned to pay a large sum of damages um, at the expense of the taxpayers. So it's all very sad, but sometimes, if you're going to have rule of law in your country, you have to get to that point.
Okay. I look forward to hearing more about this as it goes through the courts. I hope I'm still alive when it gets resolved, just because we have such delays in the court system nowadays. Thanks so much, Sam, for coming on and explaining this case to us. I look forward to speaking to you again really soon.
It was my pleasure.